session. We have Faith Mony Odhiambo. Faith is an experienced advocate with an illustrious career spanning over 13 years. She is currently the Vice President of the Law Society of Kenya, and she is also an educator at the University of Nairobi. Currently, Faith is also contesting for the LSK President, and her illustrious career has been characterized by dedication to justice, mentorship, and innovation. Faith's involvement in the legal sphere has gone beyond the courtroom and the classroom, and she has been able to play a pivotal role in various legal organizations, exemplifying her commitment to the profession, her tenure as a council member and board secretary to FIDA Kenya, and her impactful service as the Nairobi representative and vice president of the Law Society of Kenya highlight her leadership capabilities and her dedication to the welfare of the legal community. I want to welcome Faith, and Faith, as you take your moment to discuss with us, I want to pose this question. In your capacity as a practicing advocate and a leader in the legal sphere, please share with us insights on the current threats to judicial independence in Kenya and the broader East African region. Welcome, Faith.
Thank you so much. First of all, just to say it's an honor to be amongst all of you. Chief Justice, it was an honor listening to you as well, and all the presenters, my senior colleague, Mercy Decha as well, who is present. Now, as I look into your question and answer, in East Africa, what are part of the challenges as a practicing advocate and a teacher of law? I'd want to say tongue-in-cheek that we don't have experience practicing in Uganda. I hope our counterparts will allow us to soon start practicing there as well, in the spirit of the East Africanism. But as we delve into some of these challenges that we have, I want to shed light. Maybe I would touch on, I start with Tanzania. When we recently had the last East African conference, and it was honored by the president of Tanzania, and in her remarks, she indicated her unhappiness with the East African court, particularly because the government had lost so many cases in that court, and they felt that it was mostly those cases were being presented by the civil society, by the Tanzanian bar against the government, and their insistence on leaving that court. Why? Because they felt like all decisions were against them, and hence they were corrupt. Closer home, when you go also to Uganda, I raised a concern recently when the president intervened in a controversial judicial decision regarding the auctioning of a national mosque, prompting questions about the separation of powers and the autonomy of the judiciary. In his letter dated 7th December, the president indicated to the Chief Justice to review that matter and restore sanity to the judiciary. And further, when one of his district commissioners refused to appear before a court, citing that that court was corrupt, and therefore it would be an erosion of public trust in the legal system, and they could not agree to attend to that court. Now, when I come closer to our personal jurisdiction, we recently have seen a spate of conflict between the judiciary and the executive, and the Law Society as well, playing its part under Section 4, when the president made some roadside remarks regarding pending decision by the judiciary. It was actually before the Court of Appeal on the housing project, alleging that the courts were corrupt and that they would not obey court orders that were contrary to the agenda of the government. And based on that, I would like to talk about the several threats that I feel as a practitioner that are a big problem to independence of the judiciary. I'll start with the executive. Now, when you see an executive that is directly attacking the judiciary without even following the proper channels, we ask ourselves, is it because there's actual corruption, or is it because the courts have made a strong stand and the executive find that because they have the platform, the political platform, and to call for public appeal, that's the opportunity that they can use to attack the judiciary. Because in most instances, you'll find the judiciary will speak by the power of their pen. Now, the Kenyan situation today, when we see the head of state personally attacking members of the judiciary, is quite sad, because we see a situation whereby, as much as they're saying there is corruption, and I don't doubt there are elements of corrupt judicial officers, but the question is, when did they realize that the judiciary was corrupt? Is it because there's a project that is the head of state is personally interested in, or he feels strongly about that if he has not followed the due process of the law and the courts have held the same, then therefore they are corrupt? And also we look further that what has the executive even done with regards to corruption that is been there day in, day out at the cabinet offices, the public offices that we see. We don't see anything being done with regards to corruption, but we see threats, veiled and open threats being directed to the judiciary. And so executive is one of the main threats, and particularly in Kenya, this current dispensation, we feel that the threats levied against the judiciary are an attempt to erode the independence and to guide or push the pen of the judges to a particular direction. That there's all praise and pomp and promise of increase of monies and gifts here and there, as long as they make the right decision in accordance to the executive. With regards to parliament, we see a situation whereby there are court orders barring any, and I want to use the Kenyan situation for this particular instance. There are court orders in place that the housing project should not proceed. And we see parliament, even when they were actually in recess, the chairs of these two committees on housing and finance coming together and sitting and calling for public participation, irrespective of there being court orders barring the same. And so parliament is also a huge threat. We see a situation where there's that particular fear that the executive is coming together with parliament in attempt to undermine the role of the judiciary. So parliament, as much as we are supposed to expect to see parliament, particularly when the two speakers are advocates and have an oath that they have sworn to uphold the rule of law and defend the constitution, are the same ones allowing such a situation to continue, then we see the state in which the nation is going to end, the challenges that the judiciary is yet to face in the coming weeks ahead. And I also say the judiciary can also be its own threat. And why do I say that? Is when we see judicial officers bowing down to the pressures of the powers that be. While I say there's no problem on the head of judiciary meeting with the head of state, as well as the speakers in parliament, in any given period, when there are issues to discuss, I think there's no problem at all for those offices coming together. But when we see at a particular time that there's challenges with regards to independence of the judiciary, they're being called to have a sit down. And in the end, there's no open or proper, clear conclusion of what that sit down was about. If the president was raising concern about corruption, what has been done about that corruption? What have they agreed about corruption? Can you actually sit down and discuss and say, let's negotiate about corruption, or corruption must be dealt with firmly? We already have structures that have set in place to deal with the menace of corruption. Why is there a need for a sit down to come and say, we're going to do 1, 2, 3 about corruption? The laws that are there, the institutions that have already been set in place to deal with this menace. So we also read malice, because as the head of the judiciary, as much as her trajectory or the Chief Justice trajectory would be to, come up with an amicable solution, but also as the head of the judiciary, there's that expectation that she carries the mantle and the weight of that arm of government to also protect the judicial officers that are standing in the gap, that are risking life and limb to uphold the rule of law. We come from a situation where in the East African region, there's always these nuances that the judiciary is a weaponized arm of the executive, that by crippling the judges, you can be able to use the judiciary as a way to deal with your enemies, that you'll be able to ensure that either they are locked up, and if you just even look at some of the history of in Uganda, the kind of decisions that were being made with regards to any opposition leaders. You look at the situation even that we saw at Tanzania at some particular point, that even the head of the bar in Tanzania had to flee the country. We look at the position in Kenya before, when we still had one-party state. And during the Ringera purge, most of the judges were saying they had no choice, and it was the question of the red phone. So these are part and parcels of the challenges that we see, and we are hoping that the head of the judiciary might realize that the possibility of moving back to those dark ages are not far-fetched. And sitting as that head, that there's that expectation that they should stand strong, they should stand firm and protect the judicial officers that are doing the right thing, and to also hold firmly to the position that they have taken. I would also say the bar can be a threat, and also the bar can be, at the same time, your last front to stand beside you. We have seen in Tanzania the head of the bar during the late Magufuli's time coming out quite strongly, particularly where they felt that as much as the president was loved and popular, they stood against any tyrannical decisions that were made, to an extent that even there was risk to his own life, and he eventually fled the country. And he reached out to members of the various bar, including in Kenya. And we have also seen members of the Ugandan bar and Tanzanian bar reaching out to the Kenyan bar for protection at different instances. And the bar can be a strong front, and I say this in particularly in the fight to protect the rule of law. We have the opportunity as the Law Society of the East African region to also stand firm and support any bars or any judicial offices that are under attack. We saw recently East African Law Society as well came to join hands with the Law Society of Kenya as we marched on the streets fighting for the independence of the Kenyan bar. That sort of coalition coming together and standing for, the rule of law and standing together firmly is quite laudable, that they saw it fit that they, support the work that the judiciary was doing. As long as they are doing the right thing, let us support the work that these judges and judicial officers are standing in the gap to uphold the rule of law. The challenge that I agree with Justice William Mutunga, that as well as the bar can also undermine the role of the judiciary. When we have unfair attacks against the judiciary by members of the bar, particularly on unfounded reasons, I think it's a responsibility as well for members of the bar to also stand high and stand tall, that if they know the proper judicial processes, if you feel these judicial officers that are corrupt, then you know the proper channels to lodge your complaints, to lodge the challenge that you have against those judicial officers. It's your duty not only as an officer of the court, but also as to uphold the constitution and the oath of office that you took as an advocate. So advocates also should not, members of the bar should also not undermine the judiciary unfairly and unfoundedly, because to that extent, I agree that they can also be a threat to the judiciary. With regards to the civil society, I think that David Mburu comes from ICJ, but I feel that particularly the last 2 years, we're not seeing the civil society coming out as strongly as they ought to have been. When you see the judiciary is under threat and the civil society is quiet, then I believe and I feel they become part and parcel of the threats that are there. In so many instances, the work of the civil society, particularly raising their voices against injustice and abuse of the court processes and derogation of the judiciary, has been a strong foundation to support the work that to ensure that the judiciary is independent. And so the civil societies have an important role to play. And when we see elements of interference in these jurisdictions around the East Africa, and we see our civil society is quiet, the question arises is, why are they quiet? Is it that they're in agreement with what is happening, or there's an actual problem also with those institutions, or then also similarly in bed with government, or they are scared for their own lives? The civil society remains one of the best and the strongest players in this judicial system, and I hope to see more of the voices of the civil society. I also say the public has a role to play. As much as there may be emotions on different issues regarding the kind of decisions that are made, but I think as members of the public, they also have an important role to play to defend the judiciary. I would say that even when we see political leaders trying to whip up the emotions of the members of the public to turn them against institutions such as the judiciary, it's your civic and duty as a citizen to also interrogate some of these things that politicians try to whip your emotions, because the judiciary are the last wall for justice, and they stand in the gap against a tyrannical government and an overbearing parliament. And so the members of the public also have a role to play. And if they also fall prey to the whipping of their emotions by politicians, then they also will end up standing as a threat. So I say, as a practicing advocate who has practiced in some of these regions, I would want to end by saying that the rule of law is precious. And in third world countries, the nuances are always that the executive controls the parliament, the executive controls the judiciary. In Kenya, we have fought so hard for the 2010 constitution, and it would be painful to see us going back to that situation, that we lose the beauty of us being able to have a strong voice, to be able to criticize the executive, criticize parliament, to be able to raise complaints and also seek justice before these courts. The courts are the only opportunity that you will be able to, raise petitions to remove certain corrupt, even politicians and corrupt members of the executive from being able to hold certain offices. We have seen judicial decisions that have been progressive. We have been able to remove and prevent certain members that had served in the previous dispensation and they were barred by the same judiciary from having to hold office. So it gives hope that they are not above the law. And so I say the threats to judicial independence must be hard fought. When we have an independent judiciary, we have that hope that we can at least bring an equalizer to everyone. That as much as it said in the animal farm, that all animals are equal, but some animals are more equal than others. The hope that we have in an independent judiciary is that it equalizes those inequities, that you're able to present your case, you're able to stand before the halls of justice and get justice when you raise your rightful cause. So with regards to all these threats that we have, I would say that as the bar, we'll try to continue striving to uphold our oath of office, to fight for the independence of the judiciary and to protect the constitution that we hold dear. It's a responsibility that is borne upon us as lawyers, and it's a responsibility as a citizen that we fight to uphold the rule of law. Thank you.